which we explore the legal implications of the extraordinary working environment created by the coronavirus COVID-19. In the next 45 minutes, we'll consider in some detail the implications of COVID-19 for decisions to take enforcement action in particular, covering the points set out in this slide. I am Harriet Townsend, and I cover those 3 bullets under my name in the first half of the slide, before handing over to Jack Parker, who will deal with the other issues listed there. First of all, we would both like to thank you for joining us in such flattering numbers. Thank you too for your questions. There have already been many, but make use of the Q&A button at the bottom of your screen if you feel moved to do so during the webinar. You will understand that we need to prioritize questions that are most likely to be of general interest to people attending the webinar, and many of them we've found very interesting. A copy of these slides and the recording will be posted on the Cornerstone website in the next few days, and we'll prepare a written FAQ to pick up relevant questions we've not managed to cover orally. Do take a look at the website. Under the Resources tab, there's a COVID-19 unit, which collects relevant information, including, by the way, the first 3 editions of the Planning Bulletin, which you might find useful. That is where these slides and the recorded webinar will be posted in due course. Now to the subject matter of this seminar. Next slide, please, Jack. Legal context and government guidance. What is the COVID-19 context in which we're acting? I've collected on this slide 3 sources of information from the government on COVID-19. Obviously, this is a moving picture and we can't predict what will happen in the future, but this is where we are now. The first is legislation, the prohibition on leaving home without reasonable excuse, the source being Regulation 6 of the English regulations and Regulation 8 of the Welsh regulations in very similar but not identical terms. And the issue 1 of our bulletin, I should say, has links to those regulations if you'd find it useful to look at the regulations themselves. The reasonable excuse includes a requirement to travel for the purposes of work where it is not reasonably possible for that person to work from the place they are living. Then there is the prohibition on gathering of more than 2 people unless essential for work purposes. Again, there is that qualification. In that case, essential rather than whether or not it's reasonably possible. The legal issue for enforcement officers, therefore, is whether it's reasonably possible to investigate a potential breach of planning control without undertaking a site visit. This is a question of fact, which should be addressed by the officer before undertaking a site visit. The practical question is whether the visit can be undertaken safely, and if so, how to ensure that social distancing is maintained and that all concerned are protected from risk of infection. Turning to the second and third bullets on this slide, this is all the guidance there is from government to date, and it is relevant to questions of expediency, of course, but it will only be relevant in very few instances as the focus is very clear. For the most part, enforcement will not affect the fight against the virus, which is the overriding concern behind these 2 quotes. Next slide, please. Next slide, please, Jack. Thank you. So there is no amendment to the statutory framework. The powers remain as they were. There is no change as yet to the MPPF or to planning practice guidance. That, for the time being at least, remains as it was, subject to the limited point about avoiding interference with the COVID-19 response. Third bullet on this slide, the local enforcement plan. This is and remains an important guide to the exercise of the local planning authority's enforcement powers. In my opinion, planning authorities should avoid fettering the discretion to enforce by taking across-the-board decisions about what approach they will take to the exercise of their enforcement powers, even at this exceptional time. After all, as it strikes me, those affected by a use carried on in breach of planning control may suffer more during lockdown, or indeed, if the impact of a use carried on in breach of planning control is reduced by lockdown, they may suffer less. And the decision to enforce should depend upon the expediency of enforcement action. Environmental harm is always relevant. And the strong impression we have received from government is that the planning system, including enforcement, should operate in the same way as usual, as far as this is possible. Challenges undoubtedly exist around the availability of staff and remote working, but the investigation and enforcement of planning control should go on as much as possible, as usual. Next slide, please, Jack. Now I turn to time limits and start with a short review of the issue. Much of this is likely to be familiar territory. The first bullet sets out the provisions which between them establish the definition of lawful development and the context in which it can arise, lawful development certificates and ground D appeals. In sum, development is lawful if no enforcement action may be taken against that development because the time for taking enforcement action has expired. That is one of the bases upon which development is lawful. The onus is on the applicant or appellant in any case to demonstrate that the development is lawful, the standard of proof being the balance of probabilities. And in doing so, evidence is required that the breach took place more than 4 or more than 10 years ago and continued throughout the relevant period. The authority for that being the well-known case of Thurrock from as long ago as 2002. In 2011, the Supreme Court, in the case of Welwyn Hatfield, often known as the Beasley case, which was primarily concerned with concealment, the Supreme Court went so far as to endorse the approach of Lord Justice Donaldson to this particular issue in a much earlier case, Impey. That was the case in which a dog kennel use changed to a residential use, saying too much stress has been placed on the need for actual use. Next slide, please, Jack. So the applicant appellant must prove continuous use, but need not prove actual use. Emphatically, yes. And this tension is, I would suggest, a familiar part of enforcement work. So what quality of use is sufficient to continue a given use? Well, I draw attention to 3 matters that the courts consider particularly important. First, the character of the use. This will itself determine whether any particular break prevents the acquisition of immunity. See, for example, the case of Cordani against Westminster, a case which involved chairs and tables left outside a cafe on the pavement, but brought in every night for storage. Lord Justice Donaldson in Impey considered as an example during his analysis of that particular use, a flat on the market for letting, but not occupied. He said, this was clearly in residential use, and said maybe the test is whether that flat was usable for residential purposes. And that approach, as I've said, was endorsed by the Supreme Court. Mr. Justice Newman in Thurrock, his judgment being upheld later in the Court of Appeal, described the rationale for immunity as follows. The planning authority, although having the opportunity to take enforcement action, has failed to do so. Next slide, please. This slide pulls the various points I've just made at some speed. Oh, and thank you. In together and amounts to a skeleton summary of the approach likely to be taken to claims that a breach of planning control continued, or on the other hand, didn't continue during the coronavirus restrictions. Well, bearing in mind that it's a question of fact and degree, the 3 points I've dealt with already are summarized there. Look at the character of the use, look at the length of any interruption in the use, and whether the land remains suitable and available for the use during the period of interruption, such that the planning authority could have enforced against the use. And if we go to the next slide, please. This identifies 3 issues which are likely to be irrelevant. First, if one is asking, could the planning authority have enforced during the relevant period? The difficulties faced by the planning authority in enforcing during lockdown are not, in my view, relevant to this particular question. Second, fluctuations in intensity are not relevant unless they are such as to change the character of the use and thereby amount to a material change of use. And third, if the use ceases during lockdown, the fact that it is for reasons outside the control of the individual is unlikely to be relevant. And I draw attention to the approach of the inspector in a case I summarize as Miles, and the full citation is at the very end of these slides, which you'll get in due course, in which a motocross use ceased for 18 months due to foot and mouth restrictions. Now that was a challenge to a certificate of use appeal concerning various motorcycling uses carried on over farmland in Wales. The inspector held that the interruption forced on the appellant by the foot and mouth epidemic in 2001-2 did break continuity, and that the resumption of use was therefore a fresh material change of use. The High Court upheld this approach. Next slide, please. This marks a change in subject matter and is my best attempt at a motocross rider practicing social distancing. Clearly, Jack doesn't approve of it at all because he's rushed straight on to the next slide. And yes, this is where, back to the social distancing motorcycle rider. I move to powers to obtain relevant information. I'm going to run through the main powers in the Planning Act and consider their use in the current environment. As you may be aware, where there's a proposal to serve an enforcement notice, an officer authorised by the planning authority may enter to survey the land, for example, to check its condition and to check whether or not there's a breach of control taking place. As I've indicated, although lawful under coronavirus legislation, site visits are plainly less easy in the current environment. And I suggest this may be a good time to make fuller use of the information gathering powers in section 171C, the planning contravention notice, and the broader powers in section 330. Next slide, please. So the planning contravention notice briefly. Where it appears to the planning authority there may have been a breach of planning control, the planning authority may serve a PCN. Where that prerequisite doesn't apply, there is also the broader power in section 330, which I don't say much more about. Service in either case with either of these notices, and indeed enforcement notices, must accord with section 329. Email is not prohibited, but it is not, in our view, sufficient to affect service. I've noted a possibly arguable point, but really it is safer not to rely on email. What about the response to that notice? Bearing in mind email is generally going to be more convenient for all concerned, but not always. Responses are often sent by post to the planning authority. And in my view, an email response could be requested and may well be preferred by all concerned, but there is no power to require it. And therefore, all concerned with sites that are operating in breach of planning control and may be susceptible to a PCN, be aware, notices and responses to them may well arrive in post or hard copy. Next slide, please. I'm so sorry, just before coming to this slide, I had 3 practical points because so many questions came up on the question of service of notices. Simply 1, monitor the post. 2, allow for a slower postal service than usual, particularly when enforcement notices are concerned. And 3, in appropriate cases, make use of email in parallel to assist those working remotely. Thank you, Jack, and sorry about that. The Enforcement Register, section 188. I move from powers to obtain information to the duty to record information, the statutory duty to keep a register containing the information prescribed by the GDPR. And I'm particularly concerned with the requirement that the register is available for inspection. Note 2, the positive duty in the environmental information regulations to make environmental information available. From my understanding of current practice, the register is generally kept at council offices and available for inspection in person. It may be thought that publication on the council's website would be helpful to most during lockdown, and I must say, I would recommend this at all times. But it is not sufficient to meet the statutory obligation, simply because you cannot guarantee that everyone has access to the internet. In my view, someone needs to keep the register up to date, and someone needs to ensure it can be inspected by members of the public. On that note, I'm going to hand over to Jack to deal with the matters he addresses. Thank you, Jack.
Thank you, Harriet. Good afternoon, everyone. I'm going to start my section of the talk with a section on the authority for decision-making, principally addressed to those in local planning authorities, but also of interest to those served and representing those served with enforcement notices. We think issues of authority may well arise at the current time as a result of officer and/or member unavailability for whatever reason. And we think that local authorities need to be asking themselves the question, who has the authority to issue enforcement notices and take other enforcement actions. That question is going to largely depend on any individual council's constitution, and there will be some measure of variety between them. When it comes to delegated decisions, those powers which have been delegated to officers, it is important to remember that the officer or office holder to whom powers have been delegated cannot, in inverted commas, subdelegate that power. But at the same time, the scheme of delegation read as a whole may delegate powers to a group of officers, including both the named office holder and also other possible officers nominated or approved by that office holder. And there are a number of questions which follow. Firstly, is the nomination or approval required to be in writing? And if so, by whom? And secondly, another question which arises is whether the Constitution provides for powers delegated to a particular office holder to revert to a superior officer in the event of non-availability. Dealing with all of the questions under the Constitution, we say that the local authority would be well advised to think about what preemptive steps are needed in order for a broad a range as is possible of officers to have authority to take various enforcement actions, including particularly issuing notices. One particular point that sometimes arises: do enforcement notices need to be signed by the authorising officer? No, they do not. There's no requirement in law for that to happen. It should not be a matter of concern before notices are issued. Service of notices we will deal with when it comes to the Q&A session afterwards, so hang on for that. When it comes to those powers which have been ascribed to committees in any council's constitution, contrary to the position in respect of officers, a committee or subcommittee can lawfully subdelegate the power in question. And we would suggest that it be sensible for local planning authorities to ask themselves whether there was scope and whether it was sensible for any powers which would ordinarily have to be required to be exercised by a committee to be delegated to officers. If not, then, as we know, committee meetings may be held remotely, but that will inevitably make things more difficult for local planning authorities. One point to bear in mind is that if it is intended that a committee subdelegate any of their powers to officers, that committee meeting will need to be held in accordance with the regulations cited on the slide. And I don't know if we have anyone from Norwich here, but it has recently been the case that Norwich City Council acted very quickly to delegate certain committee powers to officers prior to the coming into force of these regulations, and have recently had cause to revisit that delegation in light of these regulations. So do make sure that any decisions that are made in that respect themselves accord with the Constitution and these regulations. What if an enforcement notice is issued without proper authority? Well, there's some very technical case law revolving around a distinction between notices being a nullity and simply being invalid. Cutting through that, it is likely that a notice issued without authority will need to be the subject of a claim for judicial review. It's unlikely, or it won't be a defence to a prosecution for a breach of a notice, and it's difficult to see how one could appeal against the notice under section 174 by reference to a lack of authority. So something for those advising the recipients of notices to bear in mind if there are issues of authority. Moving on from authority then, I turn to the power to vary existing enforcement notices in section 173A of the 1990 Act. This is a power to withdraw a notice and or waive or relax any of its requirements. We think this is going to be an important power for those in local planning authorities and those who are the subject of enforcement notices at the current time. Section 173A is a broad power. It includes, but is not limited to, extending time for compliance with notices and extending the time for an enforcement notice to take effect, and the variation may be effected before or after the enforcement notice takes effect. Now, it is not difficult to imagine circumstances in which the requirements of existing notices become difficult to comply with due to lockdown restrictions, and those who are subject to enforcement notices are best advised to contact the relevant local planning authority at the earliest opportunity to explore what opportunities there might be for the variation of the enforcement notice before, obviously, the recipient of the notice is in breach of it, because from that point onwards, obviously, one is liable to prosecution for breach of the notice. From the perspective of the local planning authority, it is not the case that local planning authorities can simply sit on their hands when faced with such requests, not only because when it comes to a prosecution for breach of an enforcement notice, there is the section 179(3) defence available to defendants, and it will be relevant to ask whether the recipient has done everything he could be expected to do to comply with the notice, in which case the defence may be made out, but also because any decision to vary an enforcement notice, or importantly, a decision not to vary an enforcement notice, is challengeable by way of judicial review. So something to bear in mind for everyone in those circumstances. And I'll come on at the end to talk about more specifically COVID-19 considerations. Turning to enforcement notice appeals, the big point here is that there is no power to extend time for the making of an appeal against an enforcement notice. Nothing has changed. And so an appeal must be made before the enforcement notice takes effect. If you find yourself in the position of the enforcement notice having taken effect and no appeal has been made, your only option really is to ask the local planning authority to extend time for the notice to take effect so as to give time for an appeal. Clearly, ground G appeals are going to be particularly important at the current time, and there is scope there to appeal on the basis that time for compliance with the requirements of the notice should be extended. And we are already aware of a number of inspectors' decisions in which time has been extended given the lockdown restrictions, particularly thinking of one example, an HMO, and the inspector found that due to the restrictions, for example, on taking bringing possession proceedings against the occupants of residential property, meant that the requirements of the notice should be given a longer period of time, and that is likely to apply in a number of different circumstances. As far as ground D appeals are concerned, we query whether, if the current conditions continue and we are having remote planning inquiries and planning hearings, ground D appeals are suitable to be heard in that way. And we ask whether there might be a better way to resolve any disputes between local planning authorities and recipients of enforcement notices, including third-party mediation to reach mutually agreeable solutions, which may involve variation of enforcement notice and commitments being made by the subject of the enforcement notice through section 106. Just a possibility and careful consideration will need to be given, but may be suitable in certain circumstances. What about urgent cases? Well, injunctions are still available as a remedy in both the High Court and the County Court. In the County Court, injunctions are priority 1 work, so the highest level of priority. The reality is that most planning injunctions are brought in the High Court, and that remedy is still available. There is specific guidance from the Administrative Court. They have coined the phrase immediates, where it is contended that irreversible action will take place if the court does not act. Applications should be made electronically, and we put the email address up, and electronic bundles are required. It is important to bear in mind that the evidence will need to demonstrate why the matter requires urgent attention from the court by comparison with other methods of enforcement. As is the case with many other court hearings, they will be held remotely unless it is impossible to do so. We have on that slide links to various pieces of guidance which we will make available to you afterwards along with the slides. Implementation of planning permissions. This is an issue which is being hotly debated among planning professionals. There are 2 particular issues. First, there is the issue of planning permissions expiring if works of implementation are not carried out before the deadline, and as a subset issue of that, the difficulty in discharging conditions precedent, those conditions which need to be discharged prior to the implementation of the development, with the result that the permission may not have been lawfully commenced. And the difficulties we face here are relatively obvious: restrictions on construction work, the preparation of material required for the discharge of conditions, the commercial considerations applicable to particular developments, and whether they want to be commenced at the current time or whether it is financially viable for them to do so. Various solutions are being debated. We see today that lawyers have made recommendations as to the way forward, but we haven't yet seen anything from government, and we don't know whether we will do so. In the meantime, what practical tips can we give? Well, firstly, we know that the time limit for planning permissions and reserve matters applications cannot be extended by way of a Section 73 application, and we know that the local planning authority cannot agree by informal means that requirements of conditions can be relaxed in a manner equivalent to Section 73. So those acting on behalf of developers, even if your local planning authority agrees informally to extend time, one should be very cautious about accepting any such agreement or taking any particular comfort from it. There is cautionary case law, as I have referred to there. When I say beware the decision in AgeCrest suggested that you could agree informally. It is quite an old case and has been the subject of criticism or at least has been questioned in later authorities. So what are some possible solutions? Well, as we know, minimal work is required for implementation. If you dig a trench, will you implement your development? Can that be done at relatively limited cost? Second possible solution, when it comes to the discharge of conditions precedent, we would suggest that applications are submitted even if they are not complete, with a view to additional material being submitted at a later stage. If the application is made and only approved after the deadline, work done prior to that point, in accordance with the permission, will commence the permission. That's one of the Whitley exceptions. Thirdly, we point out a matter which is very much one of last resort, not without risk, but it is worthwhile considering. Even if you cannot comply with relevant conditions, do everything that you possibly can to do so, because there is a residual exception to the principles applicable to the implementation of planning permissions, which is that if it would be an abuse of power in due course for a local planning authority to issue an enforcement notice, the works relied on will nonetheless be effective to commence development. And when we start to come out of lockdown, it may well be the case that if permissions are implemented immediately, then local planning authorities take the view, or it is open to them to take the view, that it would be abusive to take enforcement action, and so permissions may nonetheless lawfully be implemented. Final topic, I deal with Section 106 obligations and SIL. Briefly on Section 106 obligations, that they have the capacity to cause financial hardship, but unless the parties agree, they are difficult to renegotiate, and it is difficult to see how Section 106A modification applications would be a helpful way forward. Finally, SIL, we've had lots of questions about SIL. It's a very technical area. We all know that there is a lack of flexibility in the regulations in respect of non or delayed payment of SIL. I'm sure those involved with SIL have had requests for delay and deferral of payment, and that there is a risk that there will be financial difficulty for developers and development may be stymied. We know, and it is my interpretation at the very least of the regulations, that late payment interest must be applied. There is no discretion, albeit that late payment surcharges are discretionary. There are a number of competing interests here. On the one hand, local planning authorities may be spending their SIL money and may need it to come in expeditiously. On the other hand, developers, as I say, will be under financial pressure themselves, and so will want to delay payment. We're waiting again for government proposals. You may have come across the work by East Suffolk Council, who have taken a proactive attitude to the difficulties faced by developers in relation to SIL. Some of the steps that they are taking are set out on their website, and I know from having spoken to them that they are happy to discuss what they're doing with others. So please contact us and we can put you in touch if there are specific questions about the work that they're doing. The approach that they've taken is that if SIL money is paid, they will not be using it for some time, and rather than the money sitting in their bank account, it would be better spent on their employees and their supply chains. The approach that they've taken is to issue revised demand notices with a view to late payment interest not accruing by reference to that demand notice, and giving effectively developers further time to pay SIL liabilities. That particular approach is not without risk, but in circumstances, I understand that they've met with colleagues from the Ministry for Housing, Communities and Local Government who have endorsed the approach, albeit pointed out that it's not without risk. Other options include possible bespoke instalment plans, but that will depend very much on what policies you have in place so far as instalments are concerned. I've set out on that slide the key points to take away from what I've said. I won't run through those now, but perhaps you'll see them on the slide, and I suggest we turn now to deal with some of the questions that you have asked. Thanks, Harriet.
Thank you very much indeed, Jack. Yes, now to your questions, of which there have been many, and we don't have long to deal with them, so I'm going to strip them down to those which really attracted the most. I'm going to start with some questions on site visits and collecting evidence, and I'm going to look at questions about service. Then I'm going to hand over to Jack. So site visits need not be essential to meet the requirements of the regulations. We're clear about that. If it is not reasonably possible for an officer to investigate a potential breach of planning control from home, then that officer may investigate the potential breach on site. That is the law as changed by the coronavirus regulations. However, there will in addition be safeguarding and employment duties on the part of any planning authority to that member of staff, safe system of work and such like, which may themselves prohibit site visits. The coronavirus regulations do not. So I can answer a resounding yes to the question whether site visits are possible where there is no need to come into contact with anyone. For these reasons, the difficulties that staff may encounter when on site visits in coming into contact with others, there may need to be greater reliance on other sources of evidence, notably PCNs, which I spoke about in my presentation. These notices, which can require information to be provided, have considerable advantages over evidence provided by third parties, something we were asked about, given their status and the criminal sanctions for entering misleading statements or non-compliance. However, there is no reason why third-party evidence should not be relied upon and might not be made more robust by, for example, asking the individual for more information about it, perhaps a plan showing where any photographs were taken from, what they were taken with, and whether filters were applied, or rather confirming that filters were not. Also, statutory declarations can be used, diaries of activity on site, credibility enhanced by being contemporaneous and supported by the relevant affirmations. Do in all of this remember the planning authority's duties under EIR. Correspondence over enforcement investigations is environmental information almost always and likely to be disclosable on request. So those were the few points I had. I do hope they've answered the questions posed about site visits and evidence. Turning to service, we were asked if we serve an enforcement notice solely by registered post and all or some of the notices are returned, will that count as having purported to take enforcement action, and would it stop time running? The answer to this is pretty black and white. The Act distinguishes issue and service of enforcement notices. The enforcement notice is issued under sections 172 and then served, coincidentally also under the same section. But if it is not served in accordance with the Act, it has still been issued. There is, ironically, a ground of appeal, ground E, that service has not been effected in accordance with the Act. But if it has been served in accordance with the Act, and if there's then no appeal, the enforcement notice will come into effect, even if the individual was unaware of it. The Act is really pretty tough on the person in breach in this respect. And if in any doubt about that, section 1797, it may be of some interest. But this question envisages service in accordance with the Act. In such circumstances, there is no right of appeal under ground E. The owner or person in control, if they didn't receive the notice, unless an appeal is brought, the enforcement notice comes into effect and cannot be called into question. Hence the point I made that those who are operating a site in breach of planning control should ensure that they monitor the places where the planning authority must serve statutory notices. Section 329 sets these out, both for PCNs and enforcement notices. As I said, it would be sensible, in my view, for the planning authority to use electronic means to alert those who are at risk of being enforced against, but this is not a legal requirement and not sufficient to achieve service. A question that arose during the course of the webinar was whether the variation of an enforcement notice could be made by email. Again, you must distinguish the act of variation and the act of service or notification. For variation, there is no requirement of service. There's only requirement of that the planning authority notify all those who would have been served with the enforcement notice. So yes, in my view, an email notification would be adequate in that case. I hope those answers have been useful. And Jack, I know we're very short of time now. We're just over the 45 minutes, but if Jack would like to consider the questions arising on the balance of considerations when enforcing, I will hand over to him. Of course, if he's already covered those in his talk, pick them up on the way, he'll let you know right away. Thank you, Jack.
Thanks, Harriet. Well, a question that's been asked in a number of contexts is what effect does the COVID-19 lockdown have particularly on enforcement actions, the issuing of enforcement notices, issuing of prosecution proceedings, the section 1793 defence, etc. As Harriet set out at the outset, it is emphatically our view that lockdown should not mean that enforcement activities should cease, subject to specific guidance from government, which is relatively narrow in scope, and subject to social distancing restrictions. Enforcement can and should continue. It remains the case that the principles are the same. Is it expedient to issue an enforcement notice? What is the public interest in instituting a prosecution? If a prosecution has been instigated, has the recipient of the notice done everything he could be expected to do to comply with the notice? Those principles remain unchanged, but of course the impact of lockdown is likely to be an important factor in answering any of those questions. And we would suggest that in many cases, if not the majority, the impact of lockdown will be a factor to take into account in answering any of those particular questions at any stage in the enforcement process. But it's not possible really to give any hard and fast rules about the impact of the COVID-19 lockdown. The effect of it will vary between cases, and all will need to be considered on their merits. At one extreme, there are those breaches of planning control which are intended to assist in the COVID-19 response. At the other end of the spectrum, there are those who may seek to take advantage of the COVID-19 lockdown to carry out activities that would otherwise be in breach of planning control. Between those two extremes, there will be many shades of grey. No doubt the lockdown will need to be taken into account, but exactly how that is done will depend on the particular circumstances. One very specific question about the impact of the Human Rights Act and the public sector equality duty in relation to enforcement actions. Again, similar principles apply. The principles remain the same, but no doubt the impact of the COVID-19 lockdown will need to be taken into account in deciding what investigations need to be carried out to determine what matters are relevant to the Human Rights Act balance, if that applies, and or the impact on any protected characteristics, and also the balancing exercise which any human rights assessment and PSED exercise require to be undertaken. The rules remain the same, but the factors will no doubt be affected by the lockdown. Harriet, that is all I had to say on that issue.
Thank you very much indeed, Jack. And thank you everyone for joining us. This is a very new experience for us, no doubt new for you as well. If you have any feedback on the webinar, do please get in touch. Also on this slide, you see the addresses for questions, general questions about the state of the law, for instructions and inquiries. You have the emails of our clerks, and we hope very much to hear from you. We hope very much you will stay safe, stay well, and adapt as we are seeking to do to this very strange world we're working in. Thank you very much. I'm going to end the meeting now.